All rise.
Hearing the appeals to Majesty's Treasury against A and others, Queen on the application of pay, Respondent goes to Majesty's Treasury.
My Lords, my Lady, may I begin with introducing the representation. In the appeals of A, K and M, I appear together with my learned friend Mr Dan Squires for all three appellants. The Treasury are represented by Mr Jonathan Swift, Sir Michael Wood and Mr Andrew O'Connor, and they represent the Treasury in both the other appeals also. In the appeal of G, he is represented by Mr Ravinder Singh, Mr Richard Hermer and Mr Alex Balin. And in the case of HAY, who is a respondent and cross-appellant, he is represented by Mr Raza Hussain and Mr Squires again. Justice have been granted leave to intervene in all three appeals, and they are represented by Mr Fordham, Ms Fatima and Mr Steele.
Yes, so far as the last party is concerned, it was almost a matter of record that law lords were members of justice.
Yes.
They haven't ceased to be members in their new role. No objections have ever been taken on that basis, and I don't imagine there would be any objection.
I understand there is no objection today. My Lords and my Lady, before I begin the substantive appeal, could I raise a matter relating to the current status, which is that they are anonymised, of the appellants? Orders were made granting them anonymity, also covering their families, both before Mr Justice Collins in the Administrative Court and also in the Court of Appeal. I think the Court is aware that last week a number of media organisations lodged an application which was initially, it would seem, seeking to set aside or appeal the orders made below, but it is now formulated as an application to oppose any application which would be made today to extend anonymity on behalf of the appellants. And the Court, I think, is aware that an application, if it is necessary,
yes,
and we submit, in fact, it is not necessary, but to the extent it is necessary, we will be seeking to maintain the status quo to extend anonymity.
The question of whether it is necessary is something of a fast ball, because always in the past, I think, where hearings have come up from the Court of Appeal in which anonymity orders have been made, it's been treated as a matter of course that they continued in the hearing before the House of Lords.
Indeed, it may be it is something of a sterile debate,
yes,
ultimately, in circumstances where I don't think the media organisations, and I should have introduced, I'm sorry, Mrs Jeffrey Robertson,
yes,
and Mr Hudson, who are appearing for the various media organisations. But we'd say it is a bit of a sterile debate, because I think there's no doubt that this court has jurisdiction. And it has jurisdiction via a number of routes, we say, either under Section 11 of the Contempt Act or under the civil procedure rules, or under the inherent jurisdiction of the court or the Human Rights Act. And I think really that isn't in dispute. The issue really is whether today this court should, if you like, maintain the status quo, which we invite it to do, and adjourn the application to lift anonymity, because the media organisations' applications we accept raise important issues of principle, which deserve a thorough and considered hearing. We, in the time available, have not had time to marshal the kind of evidence we would wish to marshal. And no doubt the Secretary of State, who, as I think the Court is aware, opposes in relation to A, K and M the lifting of anonymity, would no doubt wish to be heard and may wish to call evidence to deal with those matters. And so my application at the outset is for the Court to grant anonymity, and it may be formally what has to happen for the purposes of Section 11, if that is the route, is that the Court has to direct the withholding of the identity, the full names of the appellants, and then, having made such an order, it can be linked to a Section 11 Contempt of Court Act order. But in any event, we submit that there are other routes to the same conclusion, and the test, as we submit on this interim basis, is the same whichever jurisdiction is invoked. But we ask the Court to extend anonymity on the same basis as the courts below, and of course those orders were never challenged at any stage, although the case was reported very widely, both on television and in the printed press.
Yes, well,
What is the test?
What is the test?
Yeah. Which you are saying, which is the same.
In circumstances where there is a balance here of convention rights, Article 8 and Article 10, the test was set out, we say, by Lord Steyn in the case of Re S. Neither article has as such precedence over the other. Where the values under the two articles are in conflict, there's an intense focus on the comparative importance of the specific rights being claimed in the individual cases, and the justification for interfering with or restricting each right must be taken into account, and it's a proportionality test.
Yes. 2 points. First of all, is there not a distinction between the other individual parties and G? G's identity is, as we understand it, already in the public domain.
Well, I better leave that to Mr. Singh to deal with.
Yes.
But obviously, there's a distinction in the sense that the Treasury letter draws a distinction of opposition. But Mr. Singh will no doubt speak for himself on that.
As far as your clients are concerned, as you have said, the issue of anonymity raises important matters of principle. It seems to us, and we've been discussing this, that the sooner those matters are resolved, the better. Equally, we understand that you need more time to deal with them, and it's desirable that the substantive hearing should not be dislocated by canvassing these issues. So our provisional conclusion is that we should make a holding order, but invite the parties to make sure that submissions on the substantive issues are finished by midday on Thursday, and deal with anonymity immediately afterwards on Thursday afternoon.
Yes, certainly.
Yes. But query whether that should apply in the case of G.
May I make that application, if it's necessary, to make it in relation to my client, Mr. G, as well? The first point we would make here is similar to what Mr. Owen has said, that simply the practicalities of the situation mean that I'm not in a position today. I would certainly wish to have the opportunity to consider the adducing of evidence from my client and possibly others. And if the matter can be held over until Thursday afternoon, in my respect for submission, that would not. My Lord has made the point that the identity of Mr. G is to some extent in the public domain. Of course, that's right. But what you couldn't do, and this is why there is still a restraint, this is why the media objected. There is a restraint on their freedom of action in the sense that the public could not necessarily, by knowing about the reporting of these proceedings, public hearing as it would be, but with only my client's initial to be known, the public could not necessarily link him to other reports that my Lord, I think, is referring to. It does raise, I accept, potentially different balance to be struck when ultimately the court has to strike a balance on the question of proportionality. Let me accept that at the level of principle. But what I would not wish to accept, my Lord, at this stage is that I should be shut out from having the opportunity, in fairness to my client, to make those arguments more fully, if that can be done on Thursday.
I mean, there are no restrictions on the designation, as I understand it, in your case, Mr. Singh, is that right?
That's right.
So, I mean, anybody who knows about it on the face of it is perfectly entitled to broadcast it.
My Lord, that's right. Can I just say two things in relation to that, my Lord? First of all, that fact, of course, has been a feature of this case from the outset. And the media were present when, for example, Mr. Justice Collins made the order he did. They had the opportunity to make representations. That hasn't been an objection that has found favour to date. But I accept that when the ultimate balance is struck, your Lordships and my Lady may take a different view. But secondly, my Lord, take, for example, the well-known case of Cardi. Now, on the face of it, Mr. Cardi is named in Regulation 881, the EU regulation in this field. There are other people who are also named in 881. I won't say anything more for present purposes, and it's perhaps obvious why I don't. But just by knowing that there is a man called Mr. G bringing this case today, the public would not necessarily know whether that's a Mr. Cardi or if it's anyone else. And Lord, it's that limited anonymity that I do wish to preserve for my client in fairness to him.
We've been shown a copy of a news release I'm sure you've seen that too, haven't you, which was dated December 2006.
Yes.
And the name is set out in full with date of birth
Yes,
and so
it
on.
is,
And
but-
we're also told that information will be added to a consolidated list, which is maintained on the financial sanctions pages. And presumably
right.
anybody can look at those pages and go down the list and
That's
look
right.
for the initial G in a name
Well,
and draw conclusions.
well, possibly so, my lord. That's an argument that I would wish to address more fully, if I can, at the substantive hearing of this application. But the point I make at the interim stage is that the public can't necessarily identify as being the same person, any particular person who is currently named in the public domain.
But why does it matter? What extra prejudice do you suffer from being named in this connection, having been the subject of an unrestricted?
Well, my lord, if I may say so, that the question of prejudice is precisely one of those that I would wish to have the opportunity to deduce evidence about, and my client and others may wish to say to this court in evidence what extra prejudice is caused. If there isn't, or if on analysis the court is not satisfied that there is, then no doubt at the substantive stage the court will say so.
It's a very odd situation where you can have an order made, but proceedings relating to the order are not to be public. The order is public, but proceedings aren't.
Lord, with respect, no, I'm not going that far. The proceedings are public, and they can be reported, save for the limited restriction as to the precise identity of the applicant. My Lord, this situation is not unique. It has arisen in the past. That doesn't mean that it should necessarily be the case that the order will be continued after Thursday. But nevertheless, the problem has arisen in other contexts. I recall one case about so-called Afghan hijackers, where there'd been a criminal appeal in the Court of Appeal Criminal Division. And so inevitably there was some knowledge in the public domain of identities, but nevertheless, at one stage at least, the courts below had made anonymity orders in relation to judicial review proceedings. So the balance has to be struck in the individual case.
But the reasons why you seek anonymity must have been disclosed to the court below.
Well, they were. And there was some consideration of that, but there wasn't, as I understand, evidence. And if there was, it certainly isn't up-to-date evidence. And your Lordship has fairly raised with me the question of what additional prejudice would be caused. That's something, as I understand it, that hasn't really been gone into, certainly not in evidence.
When were you first alerted to the intention of the press to seek to lift these anonymity orders?
When was I first alerted?
Yes.
Those instructing me, I think, were alerted on the 29th of September.
29th of September.
Yes.
So you've had rather less than a week.
And Lords, my lady,
Yes.
that's the
Made your
position.
point,
That's
yes.
the position I find myself in, unless I can assist further.
Yes. Thank you. Mr. Robertson.
Lords, we understand that these orders were given below without evidence, without reasons, and certainly with no notification to the newspapers whom I represent, including the Times, the Guardian, the Economist, Associated Press. On that basis, there is a concern that they were given, so to speak, on the nod. We alerted a week ago to the fact that in our submission, respectfully, Rule 27 plus Section 12 of the Human Rights Act requires both notification to the media and an application. We have put the Human Rights Act in front of you in this form.
Yes.
Section 12(2) says very clearly that if the person...
Yes, well, we don't wish to
Yes.
go into the merits at this point.
Of course. But I was simply saying that the duty under Section 12(2) of the Human Rights Act is to notify the media if an order that would affect the exercise of the Convention right to freedom of expression is involved. And this is such an order. Even an interim order for 4 days would affect the reporting of this case. And, my lords, may I say there are three reasons why an interim pseudonym order or anonymity order would affect the reporting of this case and affect the public's appreciation of this case. The first reason, and these are set out, your lordships may have seen the three witness statements from the deputy editor of The Economist, the assistant editor of The Guardian, and the chief reporter of The Times, all make the point, and it's been made by Lord Wolfe in the Came-Todner case, that disembodied reporting of arid and difficult to comprehend legal arguments is gives the public far less information and is given far less space in the newspapers than a case where they can provide human interest by giving the names of the parties. That is set out in...
Yes, well, we've seen these submissions.
So that is the first basis, that in fact the public will receive less information about this case, it will be less well reported, and they will understand it much less if they cannot report the names today. The second point that also appears in the bundle is that these appellants have issued press statements from behind the cloak of anonymity, as it were, giving, in an attempt to give the case a human interest. They have told the press in the press statements issued by their lawyers about Treasury officials looking at their Tesco receipts and so forth. They have condemned the government for its oppressive behaviour, the sun will set on democracy and so forth. Those press statements are there, and we say it's inappropriate that where appellants have sought to out themselves, if I can use that colloquial term, in a sense by making attacks on the government and by emphasising, no doubt, heartfelt and sincere emphasis about the way the government has been oppressive towards them, then that is a matter that disentitles them to hide behind the cloak of an anonymity order. It may very well be that those matters which were emphasised by Mr. Justice Collins and Lord Justice Sedley in this case will be better understood by the public. My Lord, the third matter is, as Lord Wolfe said in Came-Todner, that those who bring applications to the courts, judicial review in that case, must expect that their names will be known.
Well, this is getting back to the merits.
Yes. So, my Lord, on that basis, we would urge that for this first case, I must say, Your Lordship, if Your Lordship will allow me to say, that your docket reads rather like alphabet soup at the moment. The first three cases are A, B, C, and so this is clearly an important matter, and we would respectfully invite the court to deal with it first, because it will be of great importance.
Can I just ask you, Mr. Robertson, next week's two cases concern children.
Yes.
Will the media be making applications to lift the anonymity in those cases?
Although that's a matter that is, we say that it is, that's putting the cart before the horse, that it is, on principle, for the appellants in such cases who wish anonymity to seek at the outset or beforehand an order for anonymity in this court. But different principles will obviously apply to children. But in this case, where the adults are well known, G in particular, the Lordships will see not only from, as my Lord Hope has mentioned, but also from the press releases that are set out at tab 4, that there is a full-page picture of G, who has been associated with the control orders. Of course, this is a matter that has engaged the attention of the media, and he can suffer no more damage, if damage there be, by being named as an applicant in this case. So, well, that would be nice. But on a practical point, there were, we believe, no evidence put in below.
Yes, you've made that point.
And it would be, we would wish simply a short time to consider any evidence and deal with it, if necessary, by our own evidence, and whether it would be possible for this matter to be resolved on Monday morning next week rather than on Thursday afternoon. That is simply a practical point. If we're to get the evidence on Wednesday or Thursday, we'd like a short time to be able to deal with it.
We shall retire.
Yes, I know. My vote for 10 years. Should be very afraid. But even worse, I'm appearing tomorrow. Irish Supreme Court. Oh, Christ. I might not pass that piece of information on. No, please don't. Yeah. Yeah. If there's ambiguity, if he says that we have to. Yes, I think I better. You better formally make it. Formally make it. Yes. If we're responsive, I don't need to. Yes. The application, the media application doesn't mention Hay, does it? It's just but you say yes. I mean, look at this.
I can hear you.
There's no benches on.
No, as I already mentioned that, it's a disgrace. Mark. Will you be able to approve my suggestion? Finish my lunch. If there is any discussion about it, perhaps you could support.
All rise.
So far as the individual parties other than G are concerned, we have concluded that there are issues of principle that need to be canvassed. The point has been raised very late in the day, and it's reasonable that their counsel should have a further short opportunity to deal with those matters. Accordingly, we propose that we will make an interim anonymity order and propose to deal with the substance of those matters on Thursday afternoon. The order will be that until final determination of the issue of anonymity, the parties shall be granted anonymity, and no report of these proceedings shall directly or indirectly identify them or any member of their families. So far as G is concerned, his identity is already in the public domain. We have not been able to think of any valid reason for granting anonymity in his case. Mr. Singh, is there anything further you would wish to add in relation to that?
Lord.
And therefore, no anonymity will be ordered in his case, and if the order made by the Court of Appeal is binding, we lift that order. The point has been raised as to timing of provision of evidence. Evidence in relation to anonymity should be provided by the individual parties by lunchtime on Wednesday.
Well, on only one matter, might I ask for lunchtime on Wednesday for the appellant's evidence, if we could have till perhaps 9 o'clock on Thursday.
9 o'clock on Thursday to respond.
Any response? And, my Lord, while I'm on my feet, might I take the liberty of telling your lordships that there is, of course, no press box in this courtroom, and I'm told by reporters for the Times and the Guardian that they are having difficulty hearing. They're at the back of the court, and I simply draw that to your lordship's attention and perhaps hope that at lunchtime arrangements could be made for the reporters to sit more centrally or more closely to your lordships.
Well, why shouldn't everybody in court be able to hear? It seems to me that everybody ought to speak up.
My Lord, point taken.
We will have to make sure that the microphones work properly for every single person in this courtroom.
Yes, my lady.
Nobody is more important than anybody else, and if they don't, we're glad to have been told that they do not.
Yes, if anybody simply cannot hear what is being said, then they should draw that to our attention.
My Lord, that's all that I've sought to do.
Yes, Mr.
Lord, can I then turn to introduce the appeal of A, K and M? I make the point that all these appeals raise novel and important issues of constitutional law concerning the ability of the executive to make laws without the need for any form of parliamentary debate or scrutiny. They also, we submit, raise questions, difficult questions, concerning the proper balance to be struck between the competing demands of national security in the context of the threats posed by terrorism and the respect which our society accords to fundamental human rights, rights of procedural fairness and rights of access to the courts. In the appeals of A, K and M, the fundamental issue of law is whether the Treasury was lawfully empowered to introduce, almost literally overnight, an asset freezing regime which deprived them of the right to use their assets, funds and property, and which made it a criminal offence for their own family members to provide them, either directly or indirectly, with funds or economic resources without a licence from the Treasury. In the Court of Appeal, Lord Justice Sedley said that this asset freezing regime had the effect of making the individual subject to it prisoners of the state, and we say that that was an entirely accurate description of a regulation that has the effect of depriving a designated person of any resources, save those permitted by Treasury licence. Whether the executive was lawfully entitled to enact this regime by means of the Terrorism Order 2006 depends on an analysis of what Parliament intended when it enacted a very short one-clause act in 1946. That was the United Nations Act of 1946. Today, some 63 years after it was passed, is the first occasion on which the highest court in our legal system has had cause to consider its true construction. Although, as we will see, many orders in Council have been made over the last 60 years by the executive under the Section 1 UN Act procedure, none of them until now has raised fundamental issues concerning an abuse of governmental power. As a result, this court's predecessor, the Judicial Committee of the House of Lords, never considered any appeal involving the meaning and scope of this power. It is our submission on behalf of A, K and M that the 1946 Act was not, when properly analysed in its historical context and in the light of the language used, intended to be a potentially enormous, indeed potentially unlimited delegation of legislative power and authority by Parliament. Parliament did not, as the Treasury will argue, deliver a blank cheque to the executive to make law in whatever form it considered necessary or expedient to give effect to decisions of the United Nations Security Council, however those resolutions were expressed. We say that despite the apparently broad and permissive language deployed by the draftsman, Parliament cannot have intended that the UN Act should bring about such a peaceful revolution in our national life, to quote my Lord, Lord Roger, in the Hunting Act case of Jackson, in effect ceding legislative power to a duumvirate comprising the United Nations Security Council and the executive in almost all areas of public policy, and regardless of the impact of such supranational lawmaking on fundamental rights. We rely on two limiting principles of statutory construction, which we say operate to restrict the very broad language of Section 1. First, the principle of legality, which holds that a power conferred by Parliament in general terms is not to be taken to authorise interference with fundamental rights in the absence of clear words. Secondly, and it could be said this is simply implicit in the principle of legality, we rely on what we characterise as a presumption against blank cheque legislation, namely legislation which is said to devolve onto the executive an unfettered and unstructured power to make laws in any area, depending, in this case, on decisions of the Security Council. If we are right that a legislative regime such as the Terrorism Order 2006 was simply not the kind of measure which Parliament intended should be the subject of a Section 1 UN Act order in Council, in other words, the drafting of a draconian, intrusive regime which destroys an individual's ability to live anything resembling a normal life without any finding of guilt, either criminally or civilly, if we're right about that, the scope of the Section 1 power, then it means that the terrorism order is liable to be struck down as an abuse of executive power.
How far are you taking this point, Mr. Owen? Are you saying that anything that is done by the executive in the exercise of the power given by Section 1 needs to be subject to parliamentary scrutiny, not just the scrutiny that always applies where delegated legislation is being put forward, but has to be debated in Parliament, or is a sort of pick and choose system?
I understand the point my Lord is putting to me. I can't take it that far. I'm not suggesting that the Act on its face requires every single measure to be the subject of debate in Parliament. It's a question of construing whether what on the face of it I acknowledge is a broad power really is as broad as this. Because if the Treasury submission is correct, then as we'll see from the terms of Security Council Resolution 1373, all of this country's anti-terrorism legislation could have been made by order in Council. Because one looks at Article 1A and 2D of Security Council Resolution 1373, which is in the broadest of terms calling on the criminalisation of terrorism and the funding of terrorism. And if it's right that that then could be dealt with by executive order in Council, then all of our anti-terrorism legislation could be made by this means. And we say it simply cannot be, according to basic principles of statutory construction. That cannot be what Parliament intended. And so to the extent that my Lord was asking me, is there a pick-and-choose approach, I suppose the straight answer is yes. There clearly were certain measures which Parliament accepted the UN would be calling upon member states to put into domestic effect. We say that logically and sensibly, that suggests, if you like, a fully complete decision which requires measures to be taken. Don't trade with North Korea. Don't trade with Libya, and make it a criminal offence if your citizens trade with Libya or North Korea. That is the kind of measure which sensibly requires prompt and effective transposition into domestic law, and that is what Section 1 was intended to achieve. It wasn't intended.
Wouldn't that then embrace any name on the list?
In my submission, that raises a very different kind of question, and it may be one that Mr. Singh will deal with because of the different position his client is in. In my submission, there is an obvious distinction between the naming of a state which is prohibited from further trading with. For example, the state can go to the United Nations, the state can make representations to the General Assembly, and so on, and thereafter to the Security Council. An individual doesn't have that right, but there is that distinction.
Yes, I mean, I can see the suggestion that one draws a line between public measures and measures aimed against individual citizens.
Yes.
And I think Mr. Justice Collins rather thought that that was the argument that was being advanced.
Yes, I think he did.
But if you're not drawing the line there, it's not very easy to see where you do draw it.
Well, the argument was not presented in the way that Mr. Justice Collins thought it was presented. We were not suggesting that it is purely an interstate regime, but it's not necessary for the purposes of my argument, at least, to go down that particular path. Because what we do submit for the purposes of the regime under the Terrorism Act is that that is a regime which Parliament, rather the executive, has now in fact had 3 stabs at. It had a first go in the 2001 Terrorism Order, which in fact does not transpose 1373 to domestic law, nothing like it. And it's 5 years later, with 3 different primary legislation that in the meantime, where none of these measures were thought appropriate to put into primary legislation, that up pops the Terrorism Order 2006, some 6 months after Parliament had enacted the Terrorism Act 2006.
These seem to me different strands of an argument. I mean, I can... The distinction between individuals and states seems to be difficult to reconcile with Section 1, because Section 1 expressly contemplates the apprehension, trial and punishment of persons offending against the order.
Yes.
The second distinction you draw between ordinary matters and fundamental matters, as I understand it, also seems to be rather difficult, because if you can try and punish someone, that's by definition affecting their fundamental rights, their right to liberty. Yes. And the third point you've just made, which is based on the history of primary parliamentary legislation, is obviously a cogent point in a general constitutional sense. If Parliament has intervened in a specific considered way, yes, it's rather incongruous to find ministers by executive legislation taking a much wider course. But I'm not sure how far that point, I think the courts below said that point wasn't really one you were raising in those terms by itself. And I'm not sure how far you're raising it as an independent point now.
Well, rather than get drawn into answering all of those questions now, can I acknowledge the criticism that they requires greater clarity? And I hope when I come to develop the submissions, having gone through the legislative regime, the UN Charter, Section 1, and so on, but I'm sensitive to those points. The last point was certainly put as part of the argument of necessary or expedient, whether it could be said to be necessary or expedient in circumstances where Parliament had 3 stabs at legislating in this very area and chosen not to. So I'd made the point that if the court accepts our argument, the terrorism order is liable to be struck down on first principles. It's only if the court accepts that the Section 1 power is competent to authorise the enactment of such an instrument at all, then we have further submissions to make as to whether the regime which it enacts satisfies common law and convention principles of legal certainty and proportionality. We also, together with Justice, who've developed this in detail in their case, question whether the executive was entitled to set the bar at the level of reasonable suspicion of involvement in terrorist activity when it purported to give effect to the relevant Security Council resolution in circumstances where the resolution itself set a higher test for any asset freezing regime, namely that only persons who can be shown to have committed acts of terrorism should be subject to it. I propose, with that introduction, to develop my submissions in the following stages. Firstly, to take the court to the relevant provisions of the UN Charter and the United Nations Act 1946. Secondly, having done that, I propose to take you to Security Council Resolution 1373 and also 1452, which was introduced to leaven the harshness of 1373. And those are the 2 resolutions that are relevant for the Terrorism Order 2006. And so I'll show you those before making a number of points about the nature of Security Council Resolution 1373, which are relevant to why we say it's not capable or was not intended to be the kind of measure capable of being translated into domestic law by the executive via the Section 1 procedure. At stage 3, I propose to summarise for you, with the aid of a note which we have prepared, and I think it's in the supplementary bundle. It may be that this can be an agreed document, but it's a note of the provisions of primary legislation and executive orders in council which address the criminalisation of terrorist funding and financing, as well as the various powers to forfeit and freeze the assets of convicted and suspected terrorism. With that background of the legislative landscape concluded, I then intend to develop our submissions in the order set out in the case, of course not reading from the case, beginning with the legality of enacting the terrorism order at all, and then the arguments on legal certainty and proportionality. Our printed case identifies a third ground which concerns the absence at the outset of any formal procedures governing designation and challenges to designation. The Treasury took the view, that's the absence of special advocates and the exemption from RIPA and so on. The Treasury take the view that it's now wholly academic in A, K and M since the enactment of the Counter-Terrorism Act 2008. We accept it is largely academic, but Mr. Singh does not take that view in his client's case because the 2008 Act does not apply to a challenge to designation under the Al-Qaida order. So I will leave it to him to develop that submission and adopt it in advance to the extent I need to in the case, in his appeal in G. And as to the legality of adopting a reasonable suspicion test as the basis for designation, this isn't something we developed in our printed case, although it is a point we took both before the Court of Appeal and Mr. Justice Collins. We're content to adopt what I know Mr. Fordham will be saying on that matter. He's covered it thoroughly in the Justice intervention. Could I then begin with the provisions of the United Nations Charter and the UN Act? Mr. Justice Collins, I'll just give the Court the references for this. Mr. Justice Collins dealt with the content of the Charter and the UN Act, as well as the relevant Security Council resolutions which led to the terrorism order at paragraphs 3 to 5 of his judgment, which is page 19 of Appendix Part 1. And the Court of Appeal dealt with these topics between paragraphs 3 to 7, which are pages 95 to 98. And so I won't take you to those, but give you those references. But could I start by showing you the United Nations Charter, which is volume 18, tab 156. And what I just
give me that reference again.
Sorry, yes, volume 18, tab 156.
Is it Article 41 we're going to?
Well, I was going to we'll end up there, but I was just going to sketch in some other provisions first, which are relevant for other submissions. The preamble on page 1 sets out the well-known ringing words that we, the peoples of the United Nations, determined to save succeeding generations from the scourge of war, and so on, reaffirming faith in fundamental human rights, in the dignity and worth of the human person, and the equal rights of men and women, and so on. And for these ends, over the page, second line, to unite our strength to maintain international peace and security. So the important words of the preamble. The chapter 1 deals with purposes and principles. The purposes are to maintain international peace and security, and to that end to take effective collective measures, introduction of the concept of measures, for the prevention and removal of threats to peace and for the suppression of acts of aggression or other breaches of the peace, and to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations. And at Article 1.3, to achieve international cooperation in solving international problems. Article 2 sets out that the organisation and its members shall act in accordance with a number of principles, principles of sovereign equality in 1, and 2, all members, in order to assure to all of them the rights and benefits resulting from membership, shall fulfil in good faith the obligations assumed by them in accordance with the Charter. And 5, all members shall give the UN every assistance in any action it takes in accordance with the present Charter, and shall refrain from giving assistance to any state against which the UN is taking preventive or enforcement action. And then 7 deals with nothing shall authorise the UN to intervene in matters which are essentially within the democratic jurisdiction of any state, or shall require the members to submit such measures to settlement under the present Charter, but this principle shall not prejudice the application of enforcement measures under Chapter 7. Chapter 3 over the page then deals with the various organs which are set out in Article 7. Chapter 4 deals with the General Assembly and its functions and powers. And then Chapter 5 deals with the Security Council. It sets out the membership in Article 23, and then Article 24 deals with functions and powers of the Security Council. In order to assure prompt and effective action by the United Nations, its members confer on the Security Council primary responsibility for the maintenance of international peace and security, and agree that in carrying out its duties under this responsibility, the Security Council acts on their behalf. And then the specific powers in 2 are laid down in various chapters, including Chapter 7. Article 25 says that the members of the UN agree to accept and carry out the decisions of the Security Council in accordance with the present Charter. There's no reference there to the means by which those obligations are to be carried out or decisions, but it's accepted. We, of course, accept that by Article 25, Security Council resolutions create legal obligations binding on all states at the international level. Chapter 7 begins on page 12 of this document, and it covers actions with respect to threats to the peace, breaches of the peace and acts of aggression. Article 39 is relevant. The Security Council shall determine the existence of any threat to the peace, breach of the peace or act of aggression, and shall make recommendations or decide what measures shall be taken in accordance with Articles 41 and 42 to maintain or restore international peace and security. Article 40 deals with provisional measures, and then we come to Article 41, which is directly in play here. The Security Council may decide what measures, not involving the use of armed force, are to be employed to give effect to its decisions, and it may call upon the members of the UN to apply such measures. These may include complete or partial interruption of economic relations and of rail, sea, air, postal, telegraphic, radio and other means of communication, and the severance of diplomatic relations. And the examples given in that last sentence are, of course, all relating to preventive or enforcement action against another member state. Article 42 then goes on to deal with the use of force in the event that measures under Article 41 are inadequate or prove to be inadequate. Article 48, finally, over the page. The action required to carry out the decisions of the Security Council for the maintenance of international peace and security shall be taken by all the members of the UN or by some of them as the Security Council may determine. Such decisions shall be carried out by the members of the UN directly and through their action in the appropriate international agencies to which they are members. Sorry, yes, it's a misprint. Again, choice of means left to member states. Perhaps I said finally, but perhaps I ought to, while it's open, because it's relevant for the issues in the G case, to just take you to Article 103, page 25. Where it deals under the heading Chapter 16, miscellaneous provisions, in the event of a conflict between the obligations of the members of the UN under the present Charter and their obligations under any other international agreement, their obligations under the present Charter shall prevail. And that's clearly an issue that arises in the G appeal. Could I then take you to the UN?
Article 50.
Yes.
Might have assisted an argument that measures being considered were interstate measures.
Yes, I'm grateful, my Lord. Yes, I should have taken you to that. If preventive or enforcement measures against any state are taken by the Security Council, any other state, whether a member of the UN or not, which finds itself confronted with special economic problems arising from the carrying out of those measures, shall have the right to consult the Security Council. Yes, I'm grateful. And unless I'm asked, I don't think I need to read anything else. Could I then, having looked at that, take you to the UN Act, which is Volume 17, tab 136. It is, as I said in introducing it, a very short one-clause Act, April 1946, Section 1, measures under Article 41. Sorry, I should read the preamble. An Act to enable effect to be given to certain provisions of the Charter of the UN. If, under Article 41 of the Charter, signed at San Francisco on the 26th day of June 1945, the Security Council, being the article which relates to measures not involving the use of armed force, the Security Council of the United Nations calls upon His Majesty's government in the United Kingdom to apply any measure to give effect to any decision of that Council. His Majesty may, by order in Council, make such provision as appears to him necessary or expedient for enabling those measures to be effectively applied, including, without prejudice to the generality of the preceding words, provision for the apprehension, trial and punishment of persons offending against the order. I can pass over subsection 2. Subsection 3 says that any order in Council made under this section may be varied or revoked by a subsequent order in Council. Subsection 4, every order in Council made under this section shall forthwith, after it is made, be laid A, before Parliament, and B, if any provision made by the order would, if it were included in an Act of the Scottish Parliament, be within the legislative competence of that Parliament, before that Parliament. And fifthly, dealing with expenses, which I needn't deal with. Over the page, this document cites the subordinate legislation, recites, that has been made under the procedure, and one only has to look down the list to see the kind of measures that the order in Council procedure was used. It's dealing with sanctions orders against named states. It also deals with the setting up of international tribunals on a few occasions. Page 4 of this document continues that list, and really in similar form. One sees the Terrorism Order 2001, United Nations measures, at the bottom of page 3. One sees the order, and we'll come to the Terrorism Order of 2001. One then resumes with, if you like, the more typical format of this type of order. And then at the end, on page 5, penultimately listed, Terrorism Order 2009, and somewhere earlier up is the Terrorism Order 2006.
Against named states, wouldn't it be more accurate to say in respect of?
Yes, sorry, yes.
Because one is confident that many of them related to officials, officers,
yes.
And similarly in respect of embargoes, presumably.
The Lord is quite right. Yes, that would be more accurate.
Individual dealings.
Yes, indeed. I accept that.
The item referred to at the bottom, page 3,
yes,
is an example, I suppose, of something that falls outside sanctions. This is an arrangement made to enable the Netherlands to have jurisdiction over
Lockerbie,
over people who had otherwise be tried in a Scottish court.
Indeed, yes. I think that was the Lockerbie order.
But I haven't seen the order. But is it directed against individuals, or is it more a matter of rearranging jurisdiction between states?
I don't know the answer to that question. We can certainly find it out. I certainly accept my Lord Mance's point that many of these orders have included the names of individuals who are associated with government organisations, certainly. Now, going back to the wording before going on to deal with the Security Council resolutions that were made under it, which are in play here, I, of course, accept that the language that the draftsman has deployed here is very general, very broad, very permissive. It refers to any measure to give effect to any decision of the Security Council. And it's the Treasury's submission that to the extent that clear words are needed to authorise the executive to act in the way it has acted in making law in the form of the Terrorism Act, it is properly within the confines of that. We respectfully disagree for the reasons which I'll develop at greater length shortly. But we, at this stage, quite apart from the principles of the principle of legality in the blank check legislation point, rely on a submission that was made in the Hunting Act case of Jackson and not really disputed. And it's an obvious point that the literal meaning of even a very familiar expression must be rejected if it leads to a consequence which Parliament could not have intended. And if it really is the case that the use of that language to apply any measure in respect of any decision, then it really does have quite extraordinary implications in terms of what Parliament was doing in Section 1 in granting this unconstrained and unfettered and unstructured power to the executive to legislate in future, depending on how the Security Council chooses to formulate Security Council resolutions. And we go back to the point I make, if the Treasury submission is right, then all of our legislation dealing with terrorism can be made by the executive. It needs no parliamentary approval at all. And arguably, all of the legislation since the September the 11th attacks in the form of the Anti-Terrorism Crime and Security Act 2001, the Prevention of Terrorism Act 2005, the Prevention of Terrorism Act 2000, the Terrorism Act 2006, and the Counter-Terrorism Act 2008, all of them could have been lawfully made by ordering council without parliamentary debate pursuant to the Section 1 power. And we submit that simply posing that as the reality of the consequence of the Section 1 power leads one bang up against the question of whether Parliament can really be taken to have intended such an outcome by enacting this particular provision. Before turning to the
United Nations deals with international terrorism. Does the Terrorism Act only apply? Does it only apply to international terrorism? It applies to domestic.
Oh, yes, yes.
And does the United Nations Act, does it apply to domestic terrorism?
Well, on the face of it, yes. If it's right, then this Act can be used to authorise the making of an ordering council to deal with domestic terrorism, to deal with threats to other states from Britain being used by terrorists, and so on. There could be no limitation on it.
So could they, I mean, I'm just trying to, could the United Nations make a Security Council make an order respecting domestic terrorism?
Yes, that's my friend's argument. Yeah. I mean, that's the whole basis of this. The Terrorism Order 2006 is a regime which enables the Treasury to just designate individuals as terrorists or suspected terrorists and to freeze all their assets. And the people who are chosen for this regime don't figure on any United Nations list. Their cases have never been debated and therefore presented to the British. Right, here you go. And so the argument is, in effect, that by a side wind and without any acknowledgement or recognition of what Parliament was doing, it was surrendering its legislative power and authority indefinitely across the board, dependent on what the Security Council chooses to do. The fact is, and I'll come in a minute to an article, interesting article, a speech by Sir Michael Wood on the Security Council and international law, in which he acknowledges that 1373 represents a sea change in terms of what the UN Security Council does, or the way it expresses itself. But that is the Act.
I'm sorry, so when we come to Security Council resolutions, I mean, we're going to see, are we, that they are as concerned to thwart, to stifle, to repress domestic terrorism as international terrorism?
Yes, the concept, I think, really is there's no such thing as domestic terrorism, because terrorism is a threat to international peace and security wherever it occurs.
That's what's said in the recital, isn't it? 1373.
Yes.
Reaffirming that such acts, like any act of international terrorism, constitute a threat to international peace and security. That's
the jurisdiction. It's the Chapter 7 jurisdiction to identify something as a threat to international peace and security. And on this occasion, it's terrorism in all its forms. And it calls upon, as we'll see, member states to legislate. Now, of course, the answer the British were able to give is, well, we have legislated. The Terrorism Act 2000 and the Prevention of Terrorism Temporary Provisions Act were already on the statute book. And then over the years, since September the 11th, further legislative measures have been taken. But the question is whether within that legislative sequence, this document, this regime is suddenly created overnight by order in council without any debate, with extraordinary intrusion on private life and property rights, without any scrutiny. Before I go, however, to the Security Council resolution itself, could I make a number of points about the nature of Security Council decisions, which we say are relevant to the proper construction of the Section 1 power. And this is not to invite the court to embark on some exercise on deciding whether 1373 is itself ultra vires the Charter. That is a matter perhaps for the International Court of Justice. But there exists a lively debate amongst international lawyers as to whether the Security Council itself may act as a global legislator, which in turn has led some to question whether the Security Council's Chapter 7 powers are limited to specific situations or disputes. And a flavour of this debate can be gleaned, as I say, from Sir Michael Wood's very interesting lecture delivered in November 2006. He was, of course, a distinguished former legal advisor to the Foreign and Commonwealth Office, and he is now, of course, part of the Treasury team in this case. Could I just show you what his lecture has to say? It's volume 12, tab 98. It's the Hirsch Lauterpacht Memorial Lecture delivered in Cambridge in November 06, and his qualifications, Sir Michael's, are set out in at the bottom of the first page. He explains in paragraph 3 of his lecture that he set himself an ambitious task, third line down in paragraph 3. These include the nature of the Charter and the Council, how to determine when its decisions are binding, and the priority accorded to its decisions by Article 103. And at 4, he describes the difficult issues that have to be dealt with and identifies the constitutional character of the Charter of the UN as one of the topics. Does the Security Council have a legislative or quasi-judicial aspect, the priority of Charter obligations over other obligations, and the scope and effect of jus cogens norms? So that's what he was. That's where this lecture fits in. If we go to paragraph 17, on page 5, he deals with the nature of the Charter. Those who adopt a constitutional perspective to the Charter, or indeed to other areas of international law, seek to import into international affairs legal concepts from various domestic laws. The Charter is a treaty between states, a multilateral treaty with 192 parties. It is now virtually universal, relatively recent set of affairs. It is, of course, the constituent instrument or constitution of the organisation known as the UN, and as such sets out the composition and powers of its organs. But that does not mean that it has the same characteristics as a national constitution, or, I say, not the same characteristics, for example, as the Treaty of Rome. The Charter also embodies certain principles of international law, including those on the peaceful settlement of disputes and the non-use of force. And then at 18, he says this: none of this, in my view, makes the Charter the constitution for the international community. The term constitution has no particular meaning in international law. Indeed, within a particular national legal system, the term is used in many different contexts. The international community has little in common with society within a state. The appeals chamber of the Yugoslav tribunal has referred to a flawed domestic analogy, inappropriate where the international community lacks any central government, with the attendant separation of powers and checks and balances. And we rely on that point when one is looking at a decision to transpose a broad resolution calling on a member state to legislate. We say quite inappropriate to think of that type of resolution as appropriate simply to be transposed by the executive into domestic law in circumstances where there's not a central government with the legislative powers, for example, that the European community has. And warned that the transposition onto the international community of legal institutions, constructs or approaches prevailing in national law may be a source of great confusion and misapprehension. At 20, he says, I would describe, he's dealing now with the Security Council, I would describe it as follows: it's the principal organ of the UN upon which, in order to ensure prompt and effective action, the members of the organisation have conferred primary responsibility for the maintenance of international peace and security. Its powers and functions are those set out in the Charter as developed in practice. It has in particular the power to make recommendations and to adopt decisions binding on the members of the UN. In my view, that is all that needs to be said about the nature of the Council, but others seek to go further. And we respectfully say that that's correct. The reference to the ensuring of prompt and effective action is of some assistance to understanding what it was that Parliament was authorising by Section 1. It was intending to ensure that a provision that had been debated had formed into a final measure that was identifiable and logically and rationally understood to be against a member state, could then be put into law quickly, promptly, effectively, overnight by all member states. Quite a different concept that you then have come up with a general call to arms or call to legislate. But the detail of that has to be worked out in each member state according to its own legislative timetable. And to suggest that Section 1 authorised simply because it mentioned prompt and effective conversion of these resolutions, a whole broadening out of executive lawmaking powers we submit is simply not the context in which Section 1 was enacted, and the historical context must be of importance when you come to decide what Parliament's intention was. And then 23, dealing still with the Council, legislature question mark, a question often asked nowadays, particularly since the adoption of 1373 on measures against terrorism, is whether the Council may act as a legislature or, as it has been put, as global legislator. Here too the domestic law analogy is not particularly helpful. The question itself is somewhat abstract. It depends what's meant by legislature. I prefer to look at matters more concretely. Were the mandatory decisions contained in 1373 or those, and can I break off here? This is a debate about the vires of 1373 within the powers under the Charter. It's not a question of the vires under Section 1, but it is of assistance, we submit. So he says he wants to look at matters more closely. Were the mandatory decisions contained in 1373 or those contained in 1540 on non-proliferation within the powers of the Council and thus lawfully adopted or not? Put that way, it seems to me the answer is obvious, pretty obvious. Both resolutions, as it happens, were adopted unanimously and have been repeatedly reaffirmed. No state has seriously suggested that 1373 was not lawfully adopted. Such concern as was expressed about Resolution 1540 seems mostly to have been about the policy question, should the Council so act, not is it within its powers so to act. In the case of both resolutions, virtually all states are doing their best to comply, so there's no basis in state practice for suggesting that elements of these two resolutions were ultra vires, quite the contrary. And then he says the legal argument seems to boil down to this, that despite this practice, the Council is only empowered to act in relation to a specific situation or dispute. About 10 years ago, I wrote that while the Security Council has some of the attributes of a legislature, it's misleading to suggest that the Council acts as a legislature as opposed to imposing obligations on states in connection with particular situations or disputes. The Council makes recommendations and takes decisions relating to particular situations or disputes. It does not lay down rules of general application. As you will immediately spot, as I noted with some relief when I reread the passage, all I seem to be doing here is describing the then practice of the Council, not stating legal constraints. Others were not so cautious. Nowhere does the Charter state in terms that the Council's Chapter 7 powers are limited to specific situations or disputes. Is this to be implied, for example, from the language of Article 39? While breaches of the peace and acts of aggression are by their nature likely to be specific, the same cannot be said of threats. There's nothing in the language of Article 39 to suggest that the requirement that the Council determine a threat to peace refers only to a threat that is specific rather than one which is general. Such a restrictive interpretation would be contrary to the object and purpose of the Charter if, in fact, there are now urgent threats of a general nature which require urgent and global action of the kind that only the Security Council can take. Normal treaty-making procedures may be too slow. Attempts to speed them up have not met with great success. And then this. The adoption of legislative, in inverted commas, resolutions is admittedly a new development. Resolutions 1373 and 1540 are qualitatively different from what went before, not least in that they address a general threat, not a specific situation or dispute. But that doesn't make them ultra vires. No one doubts that the Council may impose obligations on states in relation to a particular dispute or situation. It may, for example, require them to impose an arms embargo on a particular state. Such a decision of the Council may well be termed legislation. The question is not whether the Council can legislate, it can and regularly does, but whether it's empowered to do so in a general way, unrelated to any specific situation or dispute. The answer turns on whether a general unspecific threat to international peace and security is sufficient for the invocation of Chapter 7 if the Council determines that international terrorism or the proliferation of weapons of mass destruction or a combination of the two is a threat to the peace, a not wholly fanciful conclusion in present circumstances, then it may take such measures as it considers necessary to maintain the peace. Depending on the nature of the threat, such measures may be specific, addressed, for example, to the threat emanating from North Korea, or they may be general, addressed, for example, to the global threat from terrorist groups. I don't see any great principle involved here, although the circumstances in which general measures are considered necessary and appropriate may prove to be rare. Well, as I say, it's no part of our argument to invite this court to rule upon the Vires argument within the confines of the Charter, but we rely on the acknowledgement that 1373 is a quite different type of resolution that the Security Council has moved towards. And the question is whether Section 1 is able to authorise the executive to interpret and make law on the back of that resolution in the way it has in the Terrorism Order 2006. Perhaps could I just refer you to the last paragraph on that page. It's an important point we submit of policy, if you like, international policy and comity. Perhaps the greatest fear of an all-powerful and unconstrained council comes when this new move towards legislation is combined with a much expanded concept of security and linkages are made between the various threats. Such concerns are understandable. The members of the council do need to exercise caution. If the council is seen to be acting routinely as a world legislature and is thought to be throwing its weight around in circumstances where this is not justified, states may simply cease to comply with its demands, whatever their legal obligations under the Charter. That would undermine the Council's authority with very serious consequences for the collective security system. And I don't think I need to read any more, but it is with respect to helpful context for the debate.
Is it possible to look at it this way, that one might be interested in the amount of scope that the SCR leaves for debate as to the way in which it is to be implemented? Yes. Some of these could be very straightforward indeed. Absolutely. And you've made the point already that prompt and effective action in matters like trade bans and so on would fall into the category of something that could be dealt with in that way, and there wouldn't really be any room for debate, bearing in mind the binding obligation which the Charter imposes. Yes. But there may be other situations, maybe you're going to say this is one where there is actually room for debate. Absolutely. And that might mark the kind of yardstick by which one decides whether or not it's a proper use of Section 1 or not. Yes.
My Lord, that is precisely our point. And we adopt what was a very helpful concept that Justice identified in their intervention of the concept of legislative design. In other words, if the measure or the resolution requires legislative design to be applied to it, to give it domestic effect, subject to the basic principles of law on which we make, the way we make law in this country, then in our submission that raises head on whether that is something that can be done by the executive via the Section 1 route. It's a matter for our domestic lawmakers to address, scrutinise and decide upon. It isn't a measure that can be promptly and effectively put on the statute book, so to speak, and made the subject of penal sanctions.
Is that an easy point to follow when the subsections, Section 1, Subsection 1, seems to contemplate that criminal offences being added as necessary or expedient in domestic law, to give effect in domestic law to something in international law which by definition won't say anything about criminal offences. It will contain a blanket prohibition on trading with a particular country or dealing in arms in a particular way. So there's quite a lot of design which is left by the section to the minister.
Well, as we'll see, if I'm successful in persuading the court to look at Hansard when this measure was debated, and I do that not to rely on any ministerial statement to show the intention of Parliament, simply to show a historical context and understanding of what Parliament was doing. But it's quite clear in my submission that the basic requirement of enacting Section 1 was to impose a duty on citizens to comply with resolutions which otherwise wouldn't exist, and to back it up, I accept, by a criminal regime. And so it's no part of my case, I don't need to take it this far, to say that that exercise is not authorised by the executive. In other words, the executive can't create a regime backed up by criminal sanctions. I don't need to go that far, and I accept on the face of it that is what it does. But it is there to create what is otherwise absent from our domestic order, which is any method whereby the government can quickly and immediately put a legal obligation on its citizens to comply with a Security Council resolution. To the extent that the principle of legality is irrelevant, of course, we say it's central. We say to that extent it has been made clear that fundamental rights can be interfered with in that particular context to enforce a particular kind of measure, but no further. Now, the point that Sir Michael makes in his article, that the UN is not a constitution for the international community, is, we submit, an important one. The supremacy of United Nations law over national law of member states was certainly not in 1946 and is not today inherent in the Charter. In Factortame number 2, Lord Bridge rejected as misconceived the idea that the ECJ, in ruling in Factortame in the way it did, was a novel and dangerous invasion by a community institution of the sovereignty of Parliament. He pointed out that the supremacy within the EC of the EU of community law over national law of member states was well established in the jurisprudence of the ECJ long before the 1972 European Communities Act. And so the limitation of its sovereignty, which Parliament accepted when it enacted the 1972 Act, was, as Lord Bridge said, entirely voluntary. The relevance of that principle, we submit, is it demonstrates, we say, that Parliament cannot be taken to have intended to surrender its legislative powers to the executive in 1946, depending on whatever way the Security Council might choose to express itself in Security Council resolutions. And we say that for these reasons, that the circumstances were, firstly, there was no settled understanding, and indeed we say there isn't still today, of the UN Security Council as a global legislator. Secondly, no settled understanding of the Charter as a constitution of the international community. Thirdly, no settled understanding of the supremacy of UN law over national law. And fourthly, to the extent there was a settled understanding, it was that Chapter 7 powers exercised under Article 41 would be focused or targeted at specific situations or disputes, and principally focused on economic or diplomatic sanctions against states whose actions threatened, in the view of the Security Council, international peace and security. Some assistance on this point about the recent history of Article 41 is to be found in Simmer's classic book on the UN Charter, which is volume 12, tab 99. It's the same one we've just been looking at. Yes, tab 99. It's a commentary on the Charter, and we copied the section here dealing with Article 41. He deals with historical origin.
What date is this?
Simmer's book is 2005, I think. I think it's relatively recent. Can I ask someone to... We'll get the front page, the inside page. Dealing here with the precursor of and partial model for Article 41 was Article 16, paragraph 1 of the League of Nations Covenant, which read as follows: should any member of the League resort to war in disregard of its covenants under Articles 12, 13 or 50, it shall ipso facto be deemed to have committed an act of war against all other members of the League, which hereby undertake immediately to subject it to the severance of all trade or financial relations, the prohibition of all intercourse between their nationals, and the nationals of the covenant-breaking state, and the prevention of all financial, commercial or personal intercourse between the nationals of the covenant-breaking state and the nationals of any other state, whether a member of the League or not. And goes on to say the sanctions listed here represented measures by individual states which the members of the League were to implement independently, the Council of the League not being involved. And then, skipping a couple of paragraphs, the author says, during the negotiations between the four powers at Dumbarton Oaks, this is before the San Francisco Treaty, agreement was easily reached on the future Security Council's power to decide on economic enforcement measures with binding effect on member states. However, long discussions arose over the question as to whether a conclusive catalogue of non-military sanctions should be included in the Charter. The Soviet Union advocated such a catalogue, and it had already drawn up a detailed list of graduated, increasingly severe reactions. In contrast, the US and Great Britain regarded this as an inappropriate limitation on the authority of the Security Council. Agreement was finally reached on an illustrative, non-exhaustive enumeration. Thus, Chapter 8, Section B, Number 3 of the Dumbarton Oaks proposals provided as follows. The Security Council should be empowered to determine what diplomatic, economic or other measures not involving the use of armed force should be employed to give effect to its decisions and to call upon members of the organisation to apply such measures. Such measures may include complete or partial disruption and so on. Now, if one puts brackets around the words after should, Security Council put brackets around should and then around measures, the wording is the same, save that the wording of Article 41 says the Security Council may decide what measures not involving the use of armed force. So I accept that the final version did not confine in the same way it did in the original drafting. The original draft covered diplomatic, economic or other measures not involving the use of armed force. But one sees the context in which Article 41 was drafted, coming and flowing from Article 16 of the League of Nations.
Suggestion of illustrative, non-exhaustive enumeration suggests an AO-STEM generous approach, doesn't it?
Can I think about that? Yes, I think it probably does. Yes, can I think about that as whether that's a point I want to advance? Over the page, it just deals with Security Council practice under Article 41. Again, this is to make the point about how matters changed dramatically. And again, of course, I accept that's not necessarily the answer to all this, but it's filling in the historical context in which Section 1 of the UN Act was passed. Although regarded as a cornerstone of the new system of collective security of the UN, Article 41 remained a dead letter for more than 2 decades. Only in 1966 could the Security Council agree on a mandatory embargo in order to force the racist minority regime of Southern Rhodesia to resign, despite the authorisation to use force for its implementation. And a significant extension 2 years later, this embargo suffered from a lack of observance by member states, and it took 13 years till it could be lifted. During the Cold War, Article 41 was applied in only one more case, that of South Africa. After long years of recommendations on trade restrictions, the Security enacted a mandatory arms embargo against South Africa in 1977, which produced limited results. In contrast, since the end of the Cold War, enforcement action under Article 41 has become a common instrument of peace maintenance. And then it goes on to deal with examples of that, which I needn't read, but the Court has seen from the measures that were passed under the Section 1 procedure. Over the page, Roman 2, the author deals with the character of the measures taken under Article 41. Unlike the measures provided for under the Covenant of the League of Nations, those under Article 41 do not necessarily possess the character of sanctions. As with all measures under Chapter 7, they need not be directed against a lawbreaker, but can be employed whenever this appears conducive to the maintenance of international peace and security. Due to this mainly preventive function, they are to be classified as enforcement measures rather than as sanctions in the strict sense. However, the Security Council is free to employ measures under Article 41 as a tool of law enforcement, and it frequently does so. And the author is making really a similar point to Sir Michael Wood, that in terms of the vires, the author considers that 1373 is not ultra vires the Charter, but of course we say, well, that may be right, but it begs the question of whether the Section 1 power is competent to translate this new type of legislative measure into domestic law via the Section 1 procedure. He then makes the point about the wording of Article 41, which I needn't dwell on. There's no argument here about whether the resolution is itself binding or not for present purposes. Before leaving this, could I just take you to page 746?
Could you start at 745? The chapter is limits of action.
Yes.
Under Article 41,
yes.
And it just caught my eye that at the end of the first paragraph,
yes,
the writer refers to travel bans.
Yes.
Those could be travel bans against individual people, undesirables. One can think of a number of examples. So I mean, that is perhaps a good example of yes. An individual being singled out, or a group of individuals for,
yes.
for treatment.
I think such a ban was employed against members of the government of Zimbabwe.
Yes.
By way of example. But again, they would follow, these would be individuals identified in a Security Council resolution. But yes, I accept that as a matter of the vires of the Council has strayed beyond, it's obvious, perhaps the narrower approach of purely economic or diplomatic sanctions against a member state to adopt other measures. We accept that.
I would have thought that a measure calling, for instance, for sanctions in relation to trading with Rhodesia would require much greater legislative design in order to introduce restrictions on individuals than the measure with which we're concerned.
Well, I think it would require it would require a different kind of legislative design. But this resolution, as we'll see, is just simply a call to take legislative measures. And who satisfies the criteria and what procedures should exist for the imposition of those measures on individuals, we submit must be a matter for Parliament to decide and could not be done by the Executive on the back of this, on this measure.
Sure, I mean, according to Simmer, page 738.
Yes.
Article 41 was first used only in 1966 with
yes.
the Rhodesian sanction.
Yes.
But if you look at our subordinate legislation under Section 1 of the 1946 Act, there's only one use of the 1946 Act until 1992. Is this right? And that's in 1979.
I had assumed, Mr. Owen, noticing this very point,
yes.
that those are the ones that are still in force.
My lady,
there might have been earlier ones
my lady may
that
be
are no longer in force, particularly as it doesn't list the 2006 order.
Yes.
And does list the 2009.
Yes. It may be it's the way that the database prints up or chooses to print the notes at the end of the section. Can we check on that? Because it's.
But I mean, did we deal with the 1966 Rhodesian Article 41 resolution by use of the Section 1 procedure under the 1946 Act?
Well, Lord, the straight answer is I don't know, but we'll find out. I've assumed that there was some.
Well, we obviously legislated, but did we do it by
yes.
order in council or by act of parliament?
Lord, I should know the answer. I'm afraid I don't, but we'll certainly find out. Yes.
It looks that we did by order in council because we've got reference to the revocations order.
Ah, well.
Yeah.
And Mr. Swift, on instructions, tells me that apparently we did. We did put it into domestic law via the order in council procedure. Maybe we ought to get hold of that. I was going to, my Lord Hope drew my attention to 745 and the reference to the travel ban. I was going to take up, perhaps at halfway down page 746, the reference to human rights problems has been dealt with, the last sentence of the main first paragraph. Thus, practice has recognised that the Security Council, when taking action under Article 41, is bound to take into account the humanitarian consequences and human rights implications and to weigh them against the interest in adopting a certain measure. Human rights problems, however, do not only arise for persons in the target state, but also, though to a lesser degree, for those in the implementing states. Embargoes, for example, would adversely affect existing contracts and businesses, partly amounting to restrictions on the protection of property, which might in some cases require compensation. Travel bans might interfere with the right to private and family life if existing residence permits for targeted individuals or even their family members are withdrawn. Usually these restrictions would be justified by a higher public interest, but in single cases undue hardship might be inevitable even if losses are compensated. In these cases, the state concerned would have to apply for an exception with the respective sanctions committee. However, since the committee's decisions are not subject to review, tension might arise. I think the authors there, in looking at the very situation which is directly raised by the G appeal, of where an individual is named, and the problem then is getting any due process or access to an effective hearing at the international level, let alone at the domestic level. Implementation is then dealt with. The implementation of measures under Article 41 has proven to be generally unsatisfactory. Apart from the cases in which military means were employed to give those measures effect, their actual enforcement depended upon the will and capabilities of the member states concerned. Centralised mechanisms were mostly weak, but began to be strengthened by the end of the 1990s. Under Article 48, it is incumbent upon member states to implement the measures decided upon by the Security Council. The choice of means to fulfil this obligation is in general left to them. Thus, while decisions of the Security Council under Article 41 bind a state in international law, it depends on the national legal system concerned whether they are directly applicable before national courts, and then goes on to deal with examples from other countries. Next paragraph, even though in most countries security sanctions resolutions are not immediately applicable in the domestic legal order, they often enjoy a particular status, especially in those states where general legislation for the implementation of UN acts exists. Only government regulations, but no further parliamentary act, would be necessary in order to transform a Security Council decision into domestic law. In other states, the same result is achieved by legislation, allowing for the governmental implementation of trade embargoes stemming from international bodies, or by directly referring to Security Council decisions for domestic prohibitions. This tendency towards accelerated implementation procedures is strengthened through the development of model laws, which may serve as a basis for executive rather than legislative decision-making once the Security Council has enacted enforcement measures. In some cases, the Security Council indicated specific measures to give effect to its decisions in the domestic legal order. In particular, has often urged states to make the violation of sanctions a criminal offence, but has in only one case ordered them to do so. In other cases, the nature of the demands set out by the Security Council might require specific changes in national law. Thus, in some states, the implementation of enforcement measures will necessitate constitutional amendments, for example, for the surrender of nationals to international or foreign courts, or for other matters related to human rights. However, a state which, because of constitutional constraints, is unable properly to enforce Security Council resolutions within its jurisdiction engages its responsibility under international law. We rely on that, at least for focusing on the question of the nature of the Article 41 measures as a matter of United Nations law. And as I say, consistently with what Sir Michael Wood has said in his lecture, it's no part of our submission to seek to persuade this court that 1373 is itself ultra vires the Charter. The real focus is on the historical context and the intention of Parliament in enacting Section 1. And at this stage, I was hoping to take the court to the references in Hansard when this was debated. I'm aware, of course, at this stage, Council is always nervous at the reaction that it provokes, and it may depend on the extent to which the court is content to look or wants to get assistance about the historical context in which the Act was passed. As I say, we do not rely on it for pepper and heart reasons. We rely really on what a number of members of the committee said in the Jackson case. We are looking at it for the historical context, and on that basis, could I take you? It's tab 12, tab 101. Earl Jowett introduced the bill on behalf of the government on the 12th of February 1946, and some 5 lines down in the first column of where he's speaking, he says, an examination has been made of all the provisions of the articles of the Charter, leading to the conclusion that there's only one article, namely Article 41, which requires immediate legislation in order to put the government in a position to fulfil the obligations as a member of the UN. It's true the Charter in various places envisages the inclusion of conventions and agreements, and that possibly the provision of these future conventions and agreements may necessitate legislation, but the time to consider whether any, and if so what, legislation is required to fulfil these agreements and conventions is when they've been adopted in final form. Over the page, Earl Jowett, at the top of the first column, deals with the big 5 in Chapter 7, and about 10 lines down, he takes up Article 41 again. Article 41, and this is the article in question here, says that the Security Council may decide what measures not involving the use of armed force are to be employed to give effect to its decisions. That, of course, is its decisions under Article 39. It may call upon members. These may include, and he sets out the wording. Your Lordships will see, therefore, that assuming the Security Council takes such a decision, and as I've said, before it can take such a decision, this country, as one of the permanent members, must concur, there's an obligation on our government to give effect to it. At present, the government have no powers to impose upon its nationals the duty to comply with such a decision. Hence, this bill, and the main part of the bill, Clause 1, provides that if under Article 41, the Security Council, and so on. Viscount Samuel, for the Conservative benches, takes up the reaction on second column on page 378, and he says, he describes the bill, which the benches on which he sits will support, as being of a limited character. It asks for the second reading of a bill to confer certain powers on His Majesty in relation to action taken under the Charter. This might have been taken, if we had so desired, as a parliamentary opportunity for discussing questions relating to the United Nations organisation in general. The great events which have been proceeding during the last few days in the close vicinity of this building and their bearing upon the future, it would be far better if those matters could be discussed on a separate occasion. Then next paragraph. This particular bill makes provision for the eventuality that coercive measures may become necessary by the UN against some state which is indulging or is apparently about to indulge in acts of aggression. Those coercive measures may be either military or non-military, what we are accustomed to speak of under the name of sanctions, economic sanctions or similar sanctions. He refers to the Charter having been recently approved, and a few lines down he says His Majesty's government have declared that the first principle of their foreign policy is support for the UN, and that declaration is, I think, unanimously approved throughout the whole country. We may feel proud our country is, as I believe the case, the first of all to take legislative action in order to show it's prepared, willing and ready to carry out to the full the obligations imposed upon member states by the Charter. Yes, sorry, I'm asked to read. Yes, and I'm asked to read the bit in between. The Charter of the UN was approved by Lordships House in a formal motion last August without dissension. I'm sure your Lordships would therefore agree it's right now to pass this legislation, which would provide generally and in advance for contingencies which might possibly arise at any time. I'm sorry, I should have read that. That's Viscount Samuel.
What do you get from this report?
Of all of it, or just that bit?
But it doesn't seem to me at the moment to add much to what one would have expected.
Which was that everybody thought that they were giving
full effect to any United Nations obligation.
Yes, it's the understanding that it was intending to put into on the statute book a means for prompt and effective action in relation to future Security Council resolutions. The settled understanding from all the speakers, as I say, was that it was in relation to economic sanctions or other measures against other states. And there was no sense of ceding sovereignty, if you like, to the UN to make law together with the executive across the board. It was a more limited understanding, and one sees it. If I can take you to the House of Commons on page 1514, Mr. Noel Baker second column, I needn't read it out, but just draw your attention to the passage which really echoes what Earl Jowett had said in the House of Lords. Under Article 41, the government must carry out. Makes the same point about under the Charter the government to have the obligation, but as the law now stands, no powers to put it into effect. Second column on column 1516, the second paragraph in that column. This is a very short bill, and I've explained it as shortly as I can, but it's not an unimportant bill. The bill would enable the UK to play its part in the vitally important measures provided in Article 41 for keeping the peace. Happily, we have no reason at present, less this morning perhaps, even though we might have thought a little while ago, for thinking that measures of this kind were required. But it's the case that after the last war, there were in the first 5 years a number of clashes between governments, a number of incipient wars which might have become wars but for action taken by the League of Nations. It's plain that such clashes may occur again and that they may be more serious. Therefore, we must be ready to play our part. This bill will make us ready. It deals with economic and diplomatic measures, with the rupture of economic relations and of all means of communications. But such methods may, in many situations, be quite decisive for keeping the peace. And as we advance with the preparation of the plans required under Article 26 for the regulation of armaments, so I believe will the importance of such economic and diplomatic measures continually increase. Mr. Morrison, in column 1517, 6 lines or 7 lines down, says it's limited to Article 41, that is to what may be called non-military sanctions. The reason for that limitation, as I understand it, is that so far as can now be foreseen with accuracy, this is the only domestic legislation which is necessary in order to fulfil this country's, to fulfil all its obligations under the Charter. And at the end, the last 6 lines of that paragraph, the procedure by way of order in council under this bill, when it becomes an act, possesses the necessary combination of speed and authority to enable instant effect to be given to these international obligations to which we are pledged. Mr. Nutting, of course, a great internationalist, but then I think just a backbencher, column 1518, offers his support for the bill, and 5 lines down says, now the history of economic sanctions in the League of Nations is not altogether a happy one, but that is not to say that economic sanctions themselves are at fault. The reason is surely to be found in the lack of power of the League of Nations as compared with what we hope will be the power of the UN. The whole question depends on the strength of the organisation. And then in the next paragraph, about just over halfway down, he says again, returns to the point, this I think shows the very considerable, indeed the vital importance of economic sanctions being universally applied. There should be no back door through which a would-be aggressor can obtain the supplies which we, the UN, are seeking to deny him through the front door. It's for that reason I hope most sincerely we shall have a satisfactory answer. And at the bottom, he says that Article 41 envisages, amongst other things, diplomatic action, the severance of diplomatic relations. I hope the House is not to be asked to spend an awful lot of time or money on this policy. Viscount Hinchinbrook takes up the question of sovereignty. He says, the Minister said it was an important bill. It certainly is important. I hope the House fully appreciates the degree of its importance. We are, in fact, sacrificing a portion of the machinery of our sovereignty in passing this bill. He directs attention to the clause. The word may in a bill is a mandatory word, not a permissive word. We shall be compelled on passing this bill to acquiesce in the decisions of the Security Council. I join with my right honourable friend in asking the Minister of State what other countries are now contemplating the passage of the bill. And he, in the next column, says this: there now only remains the veto in the Security Council to defend the sovereign rights of this country and what it may be called upon to do in regard to the making of war, the preparation for war, or as in Article 41 of the Charter, with which we are here concerned, the imposition of diplomatic and economic sanctions. So he understood it in that sense as well, although he was taking up the question of loss of sovereignty, but he's looking at it in the context of diplomatic and economic sanctions. It's very important the House should appreciate to the full we're gearing ourselves fully to the UN in advance of any other country in the world. There's left only that single right of the veto provided for in the Security Council before our sovereignty and absolute rights of saying what action, diplomatic, economic or military, we shall take are transcended altogether. At the bottom of that column, in the last paragraph, he asks the Minister to say a word on subsection 4, where provision is made to place before Parliament every order in Council. What does it mean? Has Parliament the right to amend or abolish an order in Council made in response to a request of the Security Council? Surely in all matters affecting the prosecution of war or the declaration of peace, Parliament is not concerned. So he was raising the point that actually why does... he thought that the clause in there was going to be put, the order was going to be put before Parliament for debate, and he didn't think that was right, because he thought, in effect, what was likely to be contained within an order in Council was really an emanation of the prerogative, or similar to that. Mr. Noel Baker responds at column 1524. He says he was asked about clause 1.4 concerning the orders in Council. He says, I understand the orders must be laid. I understand the orders, that does not mean that Parliament has the power to revoke or amend the orders, but it does mean that it can see in detail what are the measures proposed. And honourable members can ask questions and have a discussion on the matter and make certain that the order really carries out what is intended. The purpose of subsection 4 is to avoid the necessity of giving 40 days' notice, which, but for that, would be required under the Rules and Publications Act of 1893.
Does the Minister of State respond to the other part of, I think it was Viscount Hinchinbrook who asked what other countries are now contemplating the passage of a bill of this nature? I mean, I'd be quite interested to know whether, you know, countries like the United States, Canada, Australia, those sort of countries have got an equivalent power, and if so, whether they've deployed it in circumstances remotely like those of which we're concerned here.
Lord, the answer to your question is at column 1528. Mr. Nutting realises that that point has not been answered and says, with regard to my right honourable friend's question about other nations carrying legislation into effect, the right honourable said he was not aware what other nations were doing. Will he give an undertaking to the House he'll keep a close watch? And he says he certainly will. Yes.
So we don't get an answer, but I mean,
it had been raised in the House of Lords, I think, and Lord Samuel said that the UK was then the first, and no one else had done it.
Yes.
Yes, there's something to the same effect in column 1525, where Mr. Noel Baker is really proclaiming that this country was taking the lead in the matter.
Yes. As a matter of interest, Australia has passed Security Council, it's a different point, but Australia has passed Security Council Resolution 1373 by Act of Parliament. I'm assuming they have a similar act to the Section 1 Act, but in fact, that Section 1373 has been put into law in Australia by primary legislation.
But that's the only example you've got, is it? I mean, we don't know what any other country's done.
The answer is no, we haven't got a detailed list, but we'll look into that. I'll ask Mr. Squires to research that. The only other point, finally, on column 1525, Mr. Noel Baker returns by reference to the League of Nations to the question of sanctions and military sanctions, and at 1526, second paragraph down, says the only other time economic sanctions were attempted was against Italy in respect of the invasion of Abyssinia in 1935.
But that, so far as historical context is concerned, is really the heart of it, isn't it? Everyone assumed that it was talking about economic sanctions of the sort which the League of Nations had resolved to take against Italy because of its aggression against Abyssinia, and which failed totally.
Yes, that's the purpose of taking it to Hansard. I accept Viscount Hinchinbrook sounded an alarm about ceding sovereignty even to that extent, but to the extent it was being seen as ceding sovereignty, it was in that context.
I mean, you say even to that extent, it's to a very large extent, isn't it?
Yes, no, I accept that, yeah. There was an acknowledgement that the executive was being given a power, almost an emergency power, to put with immediate effect a measure which had been agreed on and drawn up in a Security Council resolution. My Lords and my Lady, I was now going to take you to Security Council Resolution 1373 itself. I can do it now.
Well, let's at least get it out.
Yes, it's it's volume 19, tab 162. think I can certainly, in 5 minutes, take you to the key points that I wanted to draw your attention to about this. It's drawn up on the 28th of September 2001. It sets out on the first page, at the third reaffirmation, that such acts, i.e. the terrorist attacks on America on the 11th of September, like any act of international terrorism, constitute a threat to international peace and security. Penultimate paragraph recognising the need for states to complement international cooperation by taking additional measures to prevent and suppress in their territories through all lawful means the financing and preparation of any acts of terrorism. And it's the call to take additional measures to attack financing and preparation of any acts of terrorism is what gives it this quite different quality from previous resolutions. And then at the bottom, reference that it's acting under Chapter 7, decides 1A, prevent and suppress the financing of terrorist acts. Now that is a call to legislate with no detail at all. It has no legislative design within it. It is a call on member states to legislate to prevent and suppress the financing of terrorist acts. Secondly, to criminalise the willful provision or collection by any means, directly or indirectly, of funds by their nationals or in their territories with the intention that the funds should be used or in the knowledge that they are to be used in order to carry out terrorist acts. Same point, a legislative design one. And then we come to C and D, which are the provisions which the Treasury say were ultimately transposed, more or less directly, into the Terrorism Order 2006. Freeze without delay funds and other financial assets or economic resources of persons who commit or attempt to commit terrorist acts or participate in or facilitate the commission of terrorist acts of entities owned or controlled directly or indirectly by such persons and of persons and entities acting on behalf of or at the direction of such persons and entities, including funds derived or generated from property owned or controlled directly or indirectly by such persons and associated persons and entities. D, prohibit their nationals or any persons and entities within their territories from making any funds, financial assets or economic resources or financial or other related services available directly or indirectly for the benefit of persons who commit or attempt to commit or facilitate the commission of terrorist acts of entities owned or controlled directly or indirectly by such persons and of persons and entities acting on behalf of or at the direction of such persons. So those are the asset freezing and restrictive provisions. It then goes on to call on further measures, decisions, and B is of relevance, take the necessary steps to prevent the commission of terrorist acts, including by provision of early warning to other states by exchange of information. D, prevent those who finance, plan, facilitate or commit terrorist acts from using their respective territories for those purposes against other states or their citizens. Ensure that any person who participates in the financing, planning, preparation or perpetration of terrorist acts or supporting terrorist acts is brought to justice. And finally, at G, prevent the movement of terrorists or terrorist groups by effective border controls. Now, we entirely accept that the important aim of that Security Council resolution was preventative. It was focusing on future acts of terrorism. But the question is whether that is a measure which could properly be converted directly into law by the Section 1 procedure.
So I'm just going to ask Mr. Owen, you've stressed, of course, this is relating to international terrorism in general.
Yeah.
Supposing it had been framed because of some particular terrorist attack by some state, some named state, would it make any difference? Would that make any difference to your argument or not?
To the extent that a named state...
Yes, so it was by terrorism on behalf of State X.
Such a resolution was already in force, 1267, which focused on Afghanistan and the Taliban on the basis that they had housed and trained Al-Qaida. And so that is a resolution already in existence. But if the point my lord is asking me is
what I'm really asking is, you stressed the generality of this as one of the points you made, the novelty of the kind of order.
Yes.
What I'm trying to get at is, does your argument depend on that, or would it run just the same if it related to, well, if you've given the example of Afghanistan, if it had been framed?
I think I recognise that that is a qualitatively different type of measure. It's akin to an economic sanctions measure. It invites all member states to cease supporting, hosting, and for example, allowing Afghan Taliban planes to fly into their countries and so on. I think I've implicitly accepted is one that, on the face of it, is covered by Section 1. In a sense, it doesn't require, there's no legislative design left for the domestic state to do anything further in the face of that resolution.
We'll adjourn until 2 o'clock. Yeah.